TAWUSA took its members' employer Putco to the Labour Court, seeking an interdict against a lockout effected by the employer. The union argued that Putco was not entitled to lock out its members because they were not on a strike. The Labour Court found that Putco did not have the jurisdiction to implement a lockout on employees who are not members of a bargaining council. But the Labour Appeals Court found that Putco's lockout of TAWUSA's members was lawful and reversed the decision by the Labour Court. Now the Constitutional Court ruled that TAWUSA members should not have been locked out as they did not participate in the strike and were not part of the bargaining council.
This court has come to the conclusion that the appeal must be upheld. We hold that in order for any exclusion of employees from a workplace to amount to a lockout as contemplated by Section 213 of the Labour Relations Act, that exclusion must serve the purpose of compelling the excluded employees to accept a demand. This means that a perspicuous demand must be made to the employees sought to be locked out. Axiomatically, a lockout cannot equate to a demand. A demand must precede a lockout notice. In this matter, Putco contends that it made a demand in the form of its lockout notice. A lockout notice can never constitute a demand for purposes of Section 213 of the Labour Relations Act.
The Concourt ruled that because there had not been any attempt at conciliation between Putco and TAWUSA, no industrial action, including a lockout, was permitted, and the fact that the union TAWUSA had an interest in the outcome of the dispute at a bargaining council did not mean it was party to the dispute. Naledi Mulifi, SABC News, Johannesburg.